Welcome back to the High Court Report. Today, we delve into First Choice Women's Resource Centers versus Platkin, a jurisdictional jam over what happens when state subpoenas threaten to silence speech. This case that could alter when federal courts can hear challenges to state investigations. The Supreme Court scheduled oral arguments for December 2nd. The United States will participate as amicus in this oral argument.
This case generated massive interest. It received a stunning 42 amicus briefs filed on the merits alone.
42. That's 12 more than Cox versus Sony, an incredible amount of amicus briefs, and an incredible amount of reading the justices must undertake. Plus, the court granted the United States request to participate in oral arguments, which shows just how significant the justices think this issue is.
This case puts a fascinating procedural question front and center. Can pregnancy centers go straight to federal court when state officials demand their donor lists, or must they fight it out in state court first?
And one aspect that makes this so compelling is that it's really about the clash between two fundamental principles. On one side, we have Section 1983, which Congress created specifically to give people a federal forum when state officials violate their constitutional rights. On the other side, we have this centuries-old tradition that says you can't challenge a subpoena until someone actually tries to enforce it. The stakes here go way beyond pregnancy centers. We're talking about tech companies, gun manufacturers, environmental groups. Basically, anyone who might face a hostile state investigation. The court's ruling could determine whether these groups get their day in federal court or get stuck litigating in the very state that's investigating them.
Exactly. And there's this really troubling catch-22 at the heart of this case. If you have to wait for state court proceedings and you lose, then res judicata might block you from ever getting to federal court. So you could be forced to give up your federal forum rights completely. Before we dive in, let's look at the exact question the court will decide: whether federal courts can hear First Amendment challenges to state subpoenas immediately, or whether challengers must first litigate their constitutional claims in state court.
Let me read the key constitutional text here. The First Amendment states, "Congress shall make no law abridging the freedom of speech or of the press or the right of the people peaceably to assemble."
And what's really interesting about that text is how it protects both individual speech and what the court calls associational rights. The Supreme Court says that the right to associate privately, including with anonymity, flows directly from that assembly clause.
Right? And that's where donor disclosure becomes so constitutionally sensitive. When the government demands donor lists, it's not just getting names on paper, it's potentially chilling people from exercising their fundamental right to associate with organizations they support. Now, the other crucial text here is 42 U.S.C. Section 1983, which creates a federal cause of action against anyone who, under color of state law, subjects or causes to be subjected any citizen to the deprivation of any rights, privileges, or immunities secured by the Constitution.
And that statute holds a really important history. Congress passed it in 1871, specifically because they didn't trust state courts to protect federal constitutional rights. They wanted to guarantee that people could go to federal court when state officials trampled on their rights.
So let's tell the story of how we got here. This case starts in November 2023 when New Jersey Attorney General Matthew Platkin issues what can only be described as a sweeping subpoena to First Choice Women's Resource Centers.
And just to set the scene, First Choice operates 5 faith-based pregnancy centers in New Jersey. These centers counsel women facing unplanned pregnancies, and they explicitly don't perform or refer for abortions. They make that pretty clear on their websites. But Attorney General Platkin claims he's worried that donors might be confused about what First Choice does. So he demands massive amounts of information, years of financial records, communications with donors, and here's the kicker: the names, phone numbers, and addresses of roughly 5,000 individual donors.
And we're not talking about a narrow investigation here. This subpoena covers donors who gave at benefit dinners, through church baby bottle campaigns, basically anyone who didn't give through one specific donor website. The Attorney General actually admitted he wanted to contact a representative sample of these donors to quiz them about their donations. Now, here's where the constitutional rubber meets the road. First Choice looks at this demand and says, wait a minute, we operate in an environment where pregnancy centers face arson, vandalism, and death threats. If you force us to turn over our donor list to a hostile state official, that's going to chill our donors' willingness to support us.
And they have good reason to be worried. The record shows nearly 100 criminal attacks on pregnancy centers since the Dobbs opinion leaked. We're talking about firebombs, graffiti threatening supporters, the works. So when donors see the state demanding their personal information, many of them are going to think twice about giving. So on December 13, 2023, just 2 days before the subpoena deadline, First Choice files suit in federal court. They're claiming the subpoena violates their First Amendment rights to free speech and free association. Pretty straightforward, Section 1983 case, right?
Well, that's what you'd think. But in January 2024, the federal district court throws out the case, saying it's not ripe for federal court review. The judge relies on this Fifth Circuit case called Google versus Hood, which held that you can't challenge a state subpoena in federal court until the state actually tries to enforce it.
And here's where things get really procedurally messy. During First Choice's appeal of that dismissal, Attorney General Platkin goes to New Jersey State Court in January 2024 and files an enforcement action. He basically says, First Choice won't comply with my subpoena, so I want a court order making them comply.
The state court proceedings drag on for months. Finally, in April 2024, the state judge orders the parties to negotiate the subpoena's scope and tells First Choice to respond fully to the subpoena while preserving its right to object on constitutional grounds.
Now, at this point, everyone agrees the federal case became ripe. There's an actual state court enforcement proceeding happening. So the Third Circuit dismisses First Choice's appeal as moot and sends it back to the district court to consider their request for emergency relief.
But here's where things get really frustrating for First Choice. The district court looks at this situation and says, nope, still not ripe. This time, the judge says the case won't ripen until the state court actually threatens First Choice with contempt for not complying.
So the district court basically moved the goalposts. First, the district court asserted First Choice's claim didn't ripen an enforcement proceeding. Then, the district court asserted that First Choice's claim didn't ripen until First Choice received a contempt threat. First Choice probably wondered what comes next. Not ripe until you're actually in jail?
The Third Circuit affirmed this second dismissal in a divided decision. The majority says First Choice can assert its constitutional claims in the ongoing state court proceedings, and they're confident the state court will adequately protect First Choice's federal rights. But Judge Bibas dissents, saying this case largely parallels Americans for Prosperity Foundation versus Bonta, where the Supreme Court found standing based on donor disclosure, chilling effects. And that brings us to October 2024, when the Supreme Court grants certiorari to resolve this question. Now we've got 3 sets of briefs that frame this issue in completely different ways.
So let's break down how each side argues this case, starting with First Choice's position. First Choice makes 3 main arguments, and their strongest one is probably the First Amendment chill argument. They say the moment Attorney General Platkin issued that subpoena, he injured their associational rights by creating an objective chill on donor support. And they've got some pretty compelling evidence for this chill. Several donors submitted anonymous declarations saying they would have been less likely to donate if they'd known the state might demand their personal information. Plus, First Choice explains that confidentiality is critical to their ability to recruit and retain donors, staff, and volunteers.
What makes this particularly powerful is the broader context. First Choice points to this nationwide pattern of violence and intimidation against pregnancy centers. They're arguing that any reasonable donor, knowing about these attacks, would be chilled by the prospect of having their identity disclosed to a hostile state official. Their second argument attacks the procedural ruling head-on. Drawing heavily on Nick versus Township of Scott, they argue that requiring state court litigation before federal review creates an impermissible state litigation requirement that violates Section 1983. And this is where that catch-22 becomes really important. First Choice argues they're stuck in an impossible position. They can't go to federal court without going to state court first, but if they go to state court and lose, res judicata will probably bar them from ever getting federal review of their constitutional claims.
As they put it in their brief, once a state court adjudicates First Choice's federal constitutional claims, res judicata will almost certainly bar First Choice from ever having those claims decided by a federal court. Their third argument focuses on the credible threat of enforcement. They say Attorney General Platkin's explicit threat to hold them in contempt, combined with his actual enforcement action in state court, easily satisfies the Article 3 requirements for standing and ripeness. They point out that the subpoena literally warned that failure to comply may render you liable for contempt of court and such other penalties as are provided by law. And then Platkin actually filed an enforcement action. So this isn't some hypothetical threat.
Now let's look at how Attorney General Platkin responds, because he's got some sophisticated counter-arguments. Platkin's main argument is that this subpoena is non-self-executing under New Jersey law. What that means is that First Choice faces no immediate penalty for refusing to comply. Any obligation to produce documents only comes from a future court order, and any penalties only apply if they violate that order. So Platkin argues that First Choice's claimed injury depends on contingent future events, specifically whether a state court will actually order them to produce the donor information. He says that makes the injury too speculative to support Article 3 standing.
And he makes this interesting point about negotiation. He notes that parties routinely negotiate subpoena terms before any court order issues, and they often reach compromises that eliminate the need for enforcement. Since First Choice incurs no penalties during this negotiation period, he argues there's no ripe injury.
Platkin's second argument targets the chill claim directly. He argues that First Choice hasn't established an objective chill that would affect a person of ordinary firmness. He emphasizes that his office clarified it only wanted donor information from people who gave through specific website links, significantly narrowing the scope. Plus, he argues that donors would have multiple ways to contribute without any risk of disclosure. So he's questioning whether a reasonable donor would actually be deterred by this investigation.
His third argument relies heavily on this line of Supreme Court cases, starting with Reisman versus Kaplan. These cases generally held that recipients of non-self-executing subpoenas can't bring pre-enforcement challenges. They have to wait for the enforcement proceeding and raise their objections there. Platkin argues this represents a century of history and warns that adopting First Choice's approach would open the federal courts to a flood of litigation challenging myriad subpoenas issued every day by governments across the country.
Now, the United States filed an amicus brief supporting First Choice, and their arguments are really interesting because they focus heavily on established Article 3 doctrine. The government argues that this should be a straightforward application of settled law. When a regulated party faces a credible threat that the government will bring enforcement proceedings, federal courts have Article 3 jurisdiction to hear pre-enforcement challenges.
And they emphasize two specific injuries that satisfy Article 3. First, the burden of defending against the enforcement litigation itself, and second, the prospect of eventually being forced to comply with the challenged order. As they put it, the threat of judicial enforcement inflicts concrete and imminent injuries, the burdens of the enforcement litigation, as well as the prospect of being forced to comply with the challenged order.
Their second argument directly takes on the self-executing distinction that Platkin relies on. The government argues it makes no difference for Article 3 purposes whether a subpoena is self-executing or not. They distinguish the Reisman line of cases, arguing those decisions didn't rest on Article 3 principles, but instead on Congress's choice not to create a cause of action for challenging federal agency subpoenas. But Section 1983 creates exactly that kind of cause of action for challenging state subpoenas.
The government's third argument addresses the adequacy of state court proceedings. They argue that ripeness doctrine is about timing, not forum adequacy. Just because first choice might get a fair hearing in state court doesn't mean federal courts lack jurisdiction. As they put it, a federal suit's justiciability does not turn on the adequacy of an alternative state forum.
So looking ahead to oral arguments, what are you going to be listening for, Jordan?
I'm really interested in how the justices react to this res judicata trap that first choice describes. Do they see it as a real constitutional problem, or do they think it's more theoretical?
And I'll be watching for questions about workability. Justice Roberts and others on this court really care about creating administrable rules. Platkin warns about floods of litigation, while First Choice argues their approach follows existing precedent.
The historical argument could be fascinating too. Platkin relies on this century-old tradition of requiring enforcement before challenge, but First Choice counters that Section 1983 specifically broke from those traditional limits to guarantee federal forums. Plus, there's this interesting question about how broadly the court wants to read Americans for Prosperity Foundation versus Bonta. That case found Article 3 injury based on donor disclosure requirements, but it involved an ongoing regulatory scheme rather than a one-off investigation.
You know, this case really illustrates some broader tensions in our federal system. On one hand, we want state attorneys general to be able to investigate potential fraud and protect consumers. On the other hand, we don't want them to be able to chill constitutional rights just by issuing subpoenas. And there's this federalism dimension too. Most federal circuits have been skeptical of pre-enforcement challenges to state subpoenas, but the Supreme Court's recent emphasis on federal forum rights might push them in a different direction.
What's also striking is how this case could affect the broader landscape of state investigations. We've seen attorneys general from both parties use their investigative powers pretty aggressively in recent years, investigating tech companies, oil companies, advocacy groups, you name it.
Right. And those investigations often have this political dimension where the target feels like they're being singled out for their viewpoints. If the court sides with First Choice, it could give all these groups a clearer path to federal court when they think state investigations are constitutionally motivated. But if the court sides with Platkin, it might encourage more aggressive state investigations, since targets would have fewer options for immediate federal relief.
This is also one of those cases where the court's decision could have immediate practical impact. There are probably dozens of similar cases percolating in lower courts right now, and they're all waiting to see how this comes out.
We'll definitely cover oral arguments when they happen on December 2nd. This is exactly the kind of case that often produces some really illuminating exchanges about how constitutional principles apply in practice. Thanks for joining us for this deep dive into First Choice Women's Resource Centers versus Platkin. It's a perfect example of how technical jurisdictional questions can have huge implications for constitutional rights.
If you're a practitioner who's dealt with state investigative demands, or if you work for an organization that might face this kind of scrutiny, we'd love to hear your thoughts on how this plays out in the real world. In our next episode, we cover Oliver versus City of Brandon, a case that must answer whether Supreme Court precedent prevents people from using civil rights lawsuits to get future protection when they've already been punished under the same law they're challenging, and whether Supreme Court precedent bars Section 1983 claims by plaintiffs even where they never had access to federal habeas relief. We'll break it all down for you.
Thanks for listening to the High Court Report. If you enjoyed the episode, please follow, rate, and share the podcast. You can also follow our LinkedIn page or shoot us an email with questions or comments. Talk to you soon.